19 Republic vs Dagdag. GR number 109975. February 9, 2001. Facts. On September 7, 1975, Erlinda Matias, 16 years old, married Avelino Parangan Dagdag, 20 years old, at the Iglesia Filipina Independent Church in Cuyapo, Nueva Ecija. The marriage certificate was issued by the Office of the Local Civil Registrar of the Municipality of on October 20, 1988. Erlinda and Avelino begot 2 children. The birth certificates were issued by the Office of the Local Civil Registrar of the Municipality of Cuyapo, Nueva Ecija also on October 20, 1988. A week after the wedding, Avelino started leaving his family without explanation. He would disappear for months, suddenly reappear for a few months, and then disappear again. During the times when he was with his family, he indulged in drinking sprees with friends and would return home drunk. He would force his wife to submit to sexual intercourse, and if she refused, he would inflict physical injuries to her. In October 1993, he left his family again, and that was the last that they heard from him. Erlinda learned that Avelino was imprisoned for some crime, and that he escaped from jail and remains at large to date. In July 1990, Erlinda filed with the RDC of Olongapo City a petition for judicial declaration of nullity of marriage on the ground of psychological incapacity. Since Avelino could not be located, summons was served by publication in the Olongapo News, a newspaper of general circulation. On the date set for presentation of evidence, only Erlinda and her counsel appeared. Erlinda testified and presented her sister-in-law as her only witness. The trial court issued an order giving the investigating prosecutor until January 2, 1991 to manifest in writing whether or not he would present controverting evidence, and stating that should he fail to file said manifestation, the case would be deemed submitted for decision. The investigating prosecutor conducted an investigation and found that there was no collusion between the parties. However, he intended to intervene in the case to avoid fabrication of evidence. Without waiting for the investigating prosecutor's manifestation, the trial court declared the marriage of Erlinda and Avelino void under Article 36. The investigating prosecutor filed a motion to set aside judgment on the ground that the decision was prematurely rendered since he was given until January 2, 1991 to manifest whether he was presenting controverting evidence. The Office of the Solicitor General likewise filed a motion for reconsideration of the decision on the ground that the same is not in accordance with the evidence and the law. Since the trial court denied the motion for reconsideration, the Solicitor General appealed to the CA. The CA affirmed the decision of the trial court, holding that Avelino Dagdag is psychologically incapacitated not only because he failed to perform the duties and obligations of a married person, but because he is emotionally immature and irresponsible, an alcoholic, and a criminal. Issue: did the CA correctly declare the marriage as null and void under Article 36 of the Family Code, on the ground that the husband suffers from psychological incapacity, as he is emotionally immature and irresponsible, a habitual alcoholic, and a fugitive from justice? Ruling: whether or not psychological incapacity exists in a given case calling for annulment of a marriage, depends crucially, more than in any field of law, on the facts of the case. Each case must be judged, not on the basis of a priori assumptions, predilections, or generalizations, but according to its own facts. In regard to psychological incapacity as a ground for annulment of marriage, it is trite to say that no case is on all fours with another case. The trial judge must take pains in examining the factual milieu, and the appellate court must, as much as possible, avoid substituting its own judgment for that of the trial court. In Republic vs. Molina, 268 SCRA 198, the court laid down the guidelines in the interpretation of Article 36 of the Family Code. Taking into consideration these guidelines, it is evident that Erlinda failed to comply with the above-mentioned evidentiary requirements. Erlinda failed to comply with Guideline Number 2, which requires that the root cause of psychological incapacity must be medically or clinically proven by experts. Since no psychiatrist or medical doctor testified as to the alleged psychological incapacity of her husband. Further, the allegation that the husband is a fugitive from justice was not sufficiently proven. In fact, the crime for which he was arrested was not even alleged. The investigating prosecutor was likewise not given an opportunity to present controverting evidence, since the trial court's decision was prematurely rendered.